Thank you, Mr. Chairman. Mr. Painter, I think you were here earlier, and we had some discussion of Article 3719. No member, delegate to Congress, elected official, government of the United States, government district shall be admitted to a share or part of this lease, comma, or to any benefit that may arise therefrom. The chairman has mentioned some opinion pieces and articles that have been written regarding this. And do you want to opine a bit on, I mean, we have the shall be admitted part, but then we have or to any benefit that may arise therefrom. Are there separate clauses, correct?
Well, yes. I mean, the question here is whether you want to interpret the lease as the landlord to accomplish the purpose that you were seeking to accomplish through that provision. When you say no member, no employee of the government shall be admitted to a share of the lease, do you really want to allow a real estate developer who's a private real estate developer to enter into the lease, and then the minute the lease is is signed, walk out the door and bring members of Congress in to share in the proceeds? Doesn't that undermine the entire purpose, which is to avoid government officials being on both sides of the lease, whether it is the President of the United States or members of Congress? I don't understand how that interpretation of the lease makes any sense in light of the purpose of the lease. If that interpretation is correct, that that language dies upon the signing of the lease, and that subsequently members of Congress, other government officials can be given a piece of the lease, or if the tenant becomes an elected official, they can just hold on to the lease. If that is true, then whoever drafted that lease was a fool, because it doesn't accomplish the purpose, which is to make sure that government officials are not standing on both sides of the transactions. So we can bring in lawyers, and you can always bring in a lawyer who will tell you this is a reasonable interpretation and so forth, but it makes no sense. And so if that's the proper interpretation, whoever drafted that lease for the government shouldn't be working for the government.
Well, you know, there are certainly some questions about that. But again, I would rely on the second part, or to any benefit that may arise therefrom. And if you just omit the first part, that would take care of the issue you're opining about, which is subsequent benefit to an elected official.
I would think so. I mean, the way I understand that language is you can't bring in a subsequent elected government official, or the real estate developer can't go out and bring in current government officials. That's not the way it works. It doesn't make any sense for it to work that way. I don't understand plain language to say that. And that's, by the way, only one of the issues. The other issue is whether you can somehow dodge this by saying, well, the money doesn't go to me, it goes to a trust for my benefit, or it's going to increase my wealth later. I mean, we're talking about government officials of billions of dollars. They don't need to spend all the money today. We don't say, well, you can't receive the money, we can set up a shell corporation to receive the money, you know, or a trust to receive the money. You know, that's the kind of off-balance sheet financing Enron was doing. Set up a bunch of special purpose entities to do things you yourself can't do. And I've taught plenty of that over the years. And I know lawyers will play that game, and lawyers will sign off on that game. And that's why we've had some of the corporate messes we have. But at least, can we have the United States government deal straightforwardly and honestly with the American people? If the president can't take the money, neither can a trust of which the president is the principal beneficiary.
Thank you for your testimony. Thank you, Mr.